Hi, I'm Catherine, and if you're watching this video, then you might be heading to mediation in relation to your family law property and financial matter in the near future. In this video, I'll be providing an overview of the four-step process the court engages when deciding who gets what in property matters. By understanding the four-step process, you can consider your own property and financial matter through a similar lens to that of the court. In this video, I might draw your attention to aspects of your personal case that you might not have considered were relevant or you might not have turned your mind to before. From this video, you'll also understand what to expect and what's relevant if your matter does in fact proceed to court, but I hope that won't be necessary. Throughout this video, I'll be providing you with tips in relation to how you can prepare for mediation because you'll get more out of the process the more prepared you are. Now onto the four-step process. The first step is to identify and value all solely and jointly owned assets, liabilities, and financial resources. During our intake sessions, we'll work together to create a working balance sheet which lists all solely and jointly owned assets, liabilities, and financial resources. It's important to note that the court and we at mediation will consider the asset pool at the current date, not the date of separation. So even if it's been some time since you've been separated, we will be talking about assets, liabilities, and the values of such as at the current date. One of the best things you can do to prepare for your property and financial mediation is to obtain evidence of the value of all assets, liabilities, and financial resources. That way we have more time to negotiate who gets what at the mediation and less time is spent actually negotiating and trying to come to agreed figures and values for the assets and liabilities. In relation to realty, you might obtain a few real estate appraisals or a bank valuation or bank valuations. In relation to motor vehicles, you should obtain Red Book valuations of all relevant motor vehicles. Superannuation forms part of the asset pool for consideration, so you should obtain evidence of your current superannuation balance and obtain a copy of your last superannuation statement. If either of you have an interest in a business or a company, then we'll need evidence in relation to the value of such interest. In relation to things like caravans, electronics, scooters, or gym equipment, you should obtain evidence of the same make and model or similar make and model online so we can exchange said evidence before or at mediation. In relation to liabilities, account statements should be sufficient to provide evidence of such. It's really important to have evidence in relation to the value of all assets and liabilities and financial resources before coming to mediation. And so if you have any questions in relation to how best to go about valuing certain things, please speak with your mediator and or your lawyer as soon as possible. Financial resources should also be considered. Now, a financial resource might include something like a distribution from a trust. So it's not actually in your name and it's not your legal asset, but you're obtaining a benefit from such. The second step is to assess each party's contributions. Before mediation, you should create a little document which summarizes your thoughts in relation to each party's financial and non-financial contributions. This will assist your mediator understand your position more clearly. In your summary, you should include a summary of each party's initial contributions. That is, what did each person own when they entered the relationship? You should provide a summary of all assets and liabilities and financial resources that each person had when you started living together. Have a think about each party's financial contributions. Did anyone receive any lottery wins? Did they receive any gifts of cash, for example, from family or friends? Any interest-free loans? Any inheritances? You should think about any lump sums of money that were received during the relationship and post-separation, because remember, contributions continue post-separation. So we're looking at the asset pool at the present date, not at the time of separation. So any lump sum payments that have been received during the relationship or post-separation, you should jot down a summary of how much, who received it, and how was the money spent. A common misconception that we see is that people think that things that are received post-separation aren't included, but they are included and they will be considered during court proceedings and they will be considered at mediation. And so if you've received an inheritance or you've received a financial windfall post-separation, that should also be disclosed and discussed. You should also create a summary of your perspective in relation to non-financial contributions. Who was the primary homemaker? Who vacuumed? Who cooked the meals? Who cleaned the house? Who did the gardening? Who mowed the lawns? Think about homemaker duties. Who was the primary homemaker? Another non-financial contribution is contributing as parent. Who was the primary carer of the children, or was it equal? Who had time off for paternity leave or maternity leave, if anyone? When assessing each party's contributions as parent, you might think about Well, who ensured that their uniforms were ready for school? Who did their laundry? Who packed their lunches? Who got them ready for school in the morning? Who took them to school? Who picked them up? Who did their homework with them? Who booked medical appointments? Who took the children to medical appointments? Who did the bedtime routine? Brushing the teeth, having the shower or the bath, getting the children ready for bed, reading the children bedtime stories. Those types of considerations are relevant to someone's contributions as parent. After assessing each party's contributions, the court will give a percentage in relation to each party's contributions. Now, for purely example purposes only, they might say, for example, we consider it 60% to this person and 40% to that person in relation to contribution. So 60-40 in relation to contributions. It comes as a surprise to some people. A lot of people think that there's a presumption that it starts at 50-50 or that there is a 50-50 split, which is not the case here in Australia. There is no presumption for a particular percentage outcome. It's determined on a case-by-case basis, depending on the unique circumstances and contributions of that particular family or those particular parties. The third step is assessing each party's future needs. Things to consider in relation to future needs includes things like, is there an income disparity? Does one person earn a lot more than the other person? Is child support being paid at all or as assessed? Does the parenting arrangement impact one person's ability to work and earn a living more than the other person? Is either party sick or unwell, or is there anything that might impact either party's ability to earn a living? Do the children have any special needs that impacts one or both parties' ability to earn a living? Can you think of anything that might mean that one party should receive an adjustment in their favour due to their greater future needs? Think about this before coming to mediation. So at this step of the process, the court might adjust the percentage one way or the other, depending on each party's future needs. It may or it may not. It depends, again, on the unique circumstances of the particular parties. So let's say the court says that one of the parties, so the person who was receiving the 40% in relation to contributions, the court might say, okay, well, we believe that their future needs should provide them with a 5% adjustment. So then at this third step, it can impact the overall percentage split. So the court might say, well, rather than receiving 40% due to your future needs, which are greater than the other person's, we believe the overall outcome should be changed to 45% to you and then 55% to the other person. So with this particular example, it would have gone from an assessment in relation to contributions of 40% and 60%, and then the court might say, well, we're going to give a 5% adjustment for this person due to their future needs, and so it would change the overall percentage split from 40% to 60% to 45% and 55%. To be clear, these percentages are for example purposes only. The particular percentage would depend on the unique circumstances of your particular family and your particular case. The fourth step is that the court will consider whether the proposed split and distribution is just and equitable. So when you think about who's getting what and the practicality of actually carrying out the arrangement, does it seem fair? The mediator's role is not to provide either of you with legal advice, and we strongly recommend that you both seek legal advice prior to coming to mediation, even if it's just for one appointment. Your lawyer will be able to provide you with advice in relation to where they see the range. They might tell you whether they think it's a 60-40 case, 70-30 case, 50-50 case. Of course, it will depend on your unique circumstances and the particular facts of your case. However, the mediator's role is not to provide you with legal advice, and by obtaining legal advice prior to coming to mediation, you can make legally informed decisions and legally informed offers of settlement on the day, which is just invaluable. Please note that any agreement reached at mediation is not legally binding or enforceable. However, if you both sign and date the agreement to form a heads of agreement, then that agreement is admissible in court and it can be used as evidence in court. So whether or not you sign and date an agreement at mediation is a huge deal, and we recommend that you seek legal advice before signing or dating any agreement reached. To convert your agreement reached at mediation to a legally binding and enforceable arrangement, you can engage lawyers to assist with the preparation of a binding financial agreement, or you can proceed to prepare and file with the court an application for consent orders. You don't need to engage lawyers to assist with the preparation and filing of an application for consent orders, although they can help with the process. However, with a binding financial agreement, each of you will require your own lawyer, and you'll need to obtain independent legal advice for the agreement to be binding. In relation to family law matters here in Australia, both parties have an ongoing duty to provide full and frank financial disclosure. Now, this involves exchanging various financial documents. For more information in relation to what's expected to discharge your duty to provide ongoing, full and frank financial disclosure, you should check the court's website because they have a range of really helpful information and brochures on this topic. So if you type into Google FCFCOA financial disclosure, a range of really helpful information will pop up. If a party does not provide full and frank disclosure in relation to their true assets and liabilities, that can give a party grounds to overturn any agreement, so a BFA or consent orders in future. And so it's really important that both parties adhere to their duty and discharge their duty to provide full and frank financial disclosure. So during our intake, you and I will work together to create a working balance sheet which lists all assets, liabilities, and financial resources. So again, that's step one. Then what I'd like you to do to prepare for mediation is create a summary of your assessment of contributions of both you and your ex. So again, that includes initial contributions, financial, non-financial contributions, and a list of any large sums of money that either of you received during the relationship or post-separation. So the date or rough date as to when those sums were received and how the money was spent. I want you to have a think about and create a little summary in relation to future needs. Are there any future needs, issues that we need to consider and perhaps make an adjustment for in relation to your particular circumstance? And you should really take the time to obtain evidence of all assets and liabilities. And if you feel comfortable, exchange the evidence of such with your ex-partner before coming to mediation. Because the more time you spend obtaining evidence of such, the less time we spend on discussing proposed values at mediation, and the more time we have to discuss who gets what. There are enormous benefits to resolving your matter at mediation rather than proceeding to court. Mediation costs a fraction of the cost of going all the way to a final hearing in court, so you'll have more money to spend on you and your family rather than on lawyers. At mediation, you can reach an agreement on the day without further delay. If you proceed to court, it can take months to years to reach a final hearing. Another huge benefit of mediation is that you and your ex remain in control of the outcome. If you go to court, a third party, like a judge or a registrar, will be making decisions for you. Family law property matters here in Australia are a jurisdiction where the court has wide discretion when deciding matters, and that can make it really difficult to predict the outcome. Even if you've got really experienced lawyers and barristers on each side, it's really hard to tell how the evidence might fall following cross-examination. Also, it's not uncommon for parties to disagree on the values of things and then to go to court and then to have orders to obtain a single joint expert report or valuation, and for one party to be really upset with the outcome of the valuation, which can be really difficult to predict. So there's always a lack of certainty in relation to the outcome if you do in fact proceed to court, whereas at mediation, you have a defined and clear outcome on the day. As I said, the more you prepare for mediation, the more you'll get out of the process. So have a think about the content of this video and think of some proposals that you might consider making at mediation and why you believe that your proposal or proposals are just and equitable. Let me know if you have any questions in the comment section down below, and good luck at mediation.